All right, let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff.
Will Kemp, Eric Pepperman, and Theodore Parker.
Good afternoon, Your Honor. Joel Odou and Matt Kaufman for Real Water Inc., CommunityLifestyles.com Inc., and Real Water Gold Coast.
Good afternoon, Your Honor. Jim Neale, Joan Anderson, and Mr. David Spurlock for UNFI.
Morning, Your Honor. Scott Reffis on behalf of Plaintiffs Instruments.
Good afternoon, Your Honor. Rob Robbins from Milwaukee.
All right, I think that covers all appearances. Is that correct? I think so. All right, I guess we get started. I have a little housekeeping. We had one panel member fax for us this morning, and that's, I guess, badge number 0027. And apparently they have COVID. Starting to come around again, right?
It is.
In fact, Maria's out today with COVID.
Sorry to hear that.
Yeah, so we're going to go ahead and dismiss Miss. You got that? I don't even know where she's at on the list.
Judge, can we have the badge number one more time?
That would be 010027.
Thank you.
All right. Then we have another issue. It's regarding court reporter. And I don't usually get involved in this, but I guess there's a process in place that we have regarding court reporters, because we were the last court reporting department in the building up until about 2 years ago. And we couldn't find a court reporter to replace our retiring court reporter. No one would do it. And so at that time, we switched over to a court recorder. But I'm looking here, and let me see here. I know you want to bring in a court reporter, is that correct?
Judge, I thought we had an agreement to split a reporter, and we had actually cut a check for our $25,000 that I was going to bring today, and then backed off because there seemed to be some issue here. So.
I don't even know. I don't understand the issue, to be honest with you. I'm going to be candid with you. I don't. But let me look here. I'm looking at the notes from Maria. If they want to bring in a court reporter first, it has to be approved by Judge Williams. If that's what you want to do and you agree, we'll have a court reporter. Is that what you want?
Yeah, Judge, I talked to Mr. Neale, and he doesn't seem to know anything about this. We didn't do it, so I don't know where this court reporter is.
Does it even tell me what's going on?
Your Honor, I'm as mystified by it as you. We did request dailies through your court recorder, which I understood would be made from recordings in the ordinary course and then produced each evening and distributed.
That's my understanding too, yes.
Why somebody showed up this morning, Your Honor, is a mystery beyond that. We did file a request for the dailies with the court on the 28th of August. As far as I know, sir, that's the only action we've taken other than putting down the $25,000 deposit on the court reporter who requested it.
Do you know who the court reporter is? Came in this morning?
Is she present? Hi, ma'am. Did someone... We don't want to put you on the spot. I just want to know that.
I believe she's observing. I don't believe she's the court recorder or reporter.
Oh, okay. You're just
She's
observing?
reporting to somebody else, but not us.
Media reporter.
Oh,
I'm representing Liberty Mutual Insurance, sir.
okay. I
I'm
understand.
just
And that's
observing
okay.
on
Now,
their
if
behalf.
this is a public courtroom, you don't have to identify yourself per se. Someone thought you were the court reporter.
No, sir.
So, Your Honor, this may be an entirely issue brought up by myself as a misunderstanding, and I have to apologize to the court for that. When I met this young lady this morning, it was my understanding that she was a court reporter.
Mr. Saul.
Yeah, Mr. Saul. So, Your Honor, and all the lawyers here, all the counsel here, I apologize for this transgression. Apparently, it was my misunderstanding this was brought upon this conversation.
Okay.
And I apologize.
No worries.
No worries. So we're fine there. Everybody's going through regular
Ma'am, I
protocol.
apologize for that misunderstanding.
No problem.
All right.
I'll join.
Okay, so that's taken care of.
You take the checks.
Has everybody paid their deposit?
Okay, next question.
Yeah.
Has everyone paid their deposit?
I don't know.
Judge, I have not, because I was gonna bring it down today until, I will bring it tomorrow.
Okay.
So then is that everybody?
Yeah, I have a deposit that's owed, and
I think I have a deposit that's owed as well.
My check has been mailed.
And I believe we've paid, but I'll confirm that.
Check, $25,000, and that gets, is that just sent to the court?
No, that would be.
Christine, where does it go to?
JD reporting.
JD reporting, is that, can it be mailed to this address, or?
Scott, are you not on the email? I can search for it and find it.
No,
I would,
I
at this
probably
point,
was.
I would just bring it in tomorrow
Okay, thank you.
to make sure, I mean, because they're turning away work because they've only received one deposit.
Okay,
So, we just need to make sure everybody's on board and everybody's paid before trial commences tomorrow.
okay.
All right, so that mystery is solved, hopefully. And next up, I think we had one remaining motion, is that correct? Two ma- Okay. They keep coming, huh?
Like rabbits.
Like, it's like Jason. Right, it just don't-
Your Honor, if it's all right, Mr. Kemp and I are going to excuse ourselves while the court takes up one of the two motions.
Oh, absolutely.
Thank you.
You can use the ante room, or if you want to go outside, that's fine too.
Thank you, Your Honor.
Oh, okay, this would be number 38, plaintiff's motion in limine to preclude testimony and argument regarding a purported lack of legal history and or injury claims related to real water, is that correct?
Your Honor, I believe we're going to trail that one and do the motion to strike related to Milwaukee.
I'm sorry, what motion is that? Because it was my understanding that only plaintiff's motion limiting number 38 would be heard today.
Motion to strike, plaintiff's motion to strike Milwaukee's answer for violating special master's order filed electronically January 5th, 2023. You show that?
It's docket 124.
Yeah, I don't have a binder for it.
And I thought we had submitted all of Milwaukee's, but apparently, I talked to Mr. Parker this morning, and this one maybe got missed. I'm still willing to submit it, but they aren't, so
I have that one as being subject to stipulation.
submit it, not stipulation.
Your Honor, it's our belief that we need to argue this one. I'm certainly not against Mr. Robbins submitting his opposition on the briefs, but I think there's some points that should be made and discussed with the court. I've had the opportunity, it wasn't my intention to argue this motion. I think one of my other colleagues intended to originally argue the motion. I was asked to take a look at it. I've taken a thorough look at it. There's some issues that I think the court should be made aware of. I've spoken to Mr. Robbins about the issues somewhat over the last day or two.
Just 1 second.
Yes, Your Honor.
And, Your Honor, I'm going to add, can we talk still?
Absolutely, sir.
So this motion, like you said, was filed back in January. The court was, I think, Your Honor was ready to rule on it back in March at one point, and then it's been supplemented to add some additional issues. So I don't know if you need time to prepare on the supplemental stuff, but I know at one point it seemed like you were ready to rule on it.
And Mr. Robbins, I can tell you honestly, I've ruled on so many motions.
You don't remember it?
I mean, I don't know how many motions since March, but in this case, how many motions have I ruled on so far?
Well, there's 116 total,
Yes.
and if we're down to 2, I mean, it's down to
Th-
140.
This was filed back in January.
No, I
That
understand.
jogs your memory.
The only additional information that Mr. Robbins is correct, there was supplemental briefings submitted in August, last month. So, again, I think that's part of the reason why.
And we'll go ahead and get it done, and
Thank you.
might as well. I'm gonna step down just for 1 second.
Yes, sir.
So I'm a California.
All right,
Yeah.
please be seated, thank you.
All right, I guess we get started, Mr. Parker.
Thank you, Your Honor. Your Honor, you've had a chance to grab the briefs, I'm assuming?
Oh, yeah.
And this motion has somewhat of a tortured past. Thank you, Mr. Robbins. You know, I'm here twice a month doing shows. And, Your Honor, there was a motion, an opposition, a reply, supplemental briefings in between, and then as late as August, additional briefings. So I have before me 6 briefs on what's typically, as you know, typically 3 briefs. So did the court see all 6 of those briefs?
Yes.
All right. So just to give the court an idea, time-wise, of what we're dealing with, plaintiff's complaint was filed May 12, 2021. Milwaukee submitted his first NRCP 16.1 disclosures October 15, 2021. Now, certainly the court's familiar with Rule 16.1, and we've talked about it quite a bit over the last month and a half of pretrial motions. This motion involves not only 16.1 in terms of the disclosure of documents, but also the disclosure of insurance policies. And certainly the court's familiar with the obligations under Rule 16.1 when it comes to the disclosure of insurance policies. Rule NRCP 16.1A1, capital A, provides that without a request in terms of insurance companies, certain insurance policies, the defendant is required to provide for inspection and copying, as under Rule 34, any insurance agreement under which an insurance business may be liable to satisfy all or part of a possible judgment in the action, or to indemnify or reimburse for payments made to satisfy the judgment, and any disclaimer or limitation of coverage or reservation of rights under any such insurance agreement. And that's, in fact, it's NRCP 16.1 A, small a, 1, capital A, Romanet 5. I point that out because I believe from the briefings, Your Honor, the insurance issue may have been clouded by all of the document, email-related issues. And I wanted to put that on the court's mind because the rule first requires it, and then secondarily because it has not been fully complied with as of this date. Under Rule NRCP 37B1, the court has, within its discretion, certain sanctions that can be imposed for failing to comply with 16.1. One being striking pleadings in whole or in part, prohibiting the disobedient party from supporting or opposing designated claims or defenses, or from introducing designated matters in evidence, directing that the matters embraced in the order or other designated facts be taken as established for purposes of the action as a prevailing party claims. Now, one of the cases cited in our briefing, plaintiff's briefing, deals with the failure to produce insurance information. There was another case that I was able to find over the weekend, and both these cases, by the way, are 10th Circuit cases. But this case is the Sun River Energy Inc. versus Nelson, 800 Fed 3rd, 1219, 10th Circuit, 2015.
I object, Your Honor. It wasn't in any of the briefing.
Objection noted, sir.
Thank you.
The 10th Circuit affirmed an award of Rule 37C sanctions against counsel for failure to disclose the company's directors and officers' D&O insurance policy in its initial disclosure. And again, Nevada has a policy of looking to the federal case law when the rules are similar. In this case, Rule 37 is very similar, and the initial disclosures in federal court under Rule 26 very similar when it comes to insurance disclosures to Nevada's NRCP 16.1 requirement. And in that case, the plaintiff had a director's and officer's liability insurance policy, including employment practices and securities claims coverage, which arguably provided coverage for certain counterclaims and that the defendant was required to make or disclose. In this case, Your Honor, we requested in written discovery after the insurance policy was not provided by pursuant to 16.1. We sent interrogatories, request for deduction, and request for admissions on June 17, 2022. Milwaukee asked for an extension. The extension was granted. Milwaukee finally responded virtually 3 months later to the written discovery. And we've actually attached to the motion, Your Honor, as Exhibit 2, the responses to interrogatories, and Exhibit 3, the responses to requests to produce. And Your Honor, if you could turn to Exhibit 2. The interrogatories at issue for this motion will be interrogatories number 7, 9, 11, and 13. So 17 deals with a request for notices related to the MW series of meters. So that's not the insurance issue. This is the production of documents, which we'll get to under 16.1 and NRCP 34. That's 7. The response to interrogatory number 7 is the responding party is unaware of any complaints, letters, claim, notice, or other report or document concerning an incident in which the purchaser of an MW500 ORP meter was injured by an MW500 ORP meter while using it. Interrogatory number 9 is a particular concern in terms of insurance. Interrogatory number 9 says, and I'm not going to read the entire document, but you can see lines 20 through 28 on page 10, including on page 11, line 2. State whether there are one or more policies of insurance extending coverage to you or whether you are a party to, and it goes on, Your Honor. So at this point, we're seeking more than just the one policy that was ultimately disclosed by Milwaukee. Sometime later, and we'll get to this, Mr. Robbins certainly would mention it because it's in his opposition papers, they eventually provided the underlying policy for Milwaukee from 2016 to 2022, I believe, Your Honor. But to date, they've not provided any of the parent company insurance policies. And that would be the policies from SID, Your Honor. Interrogatory number 9, the response on page 11. This is the one policy that was provided, and it was the Liberty Mutual policy, and the policy number is there at lines 7 and 8, Your Honor. If you go to interrogatory number 11, Your Honor, this request asks, do you contend that it was not feasible to manufacture the subject meter to have self-adjusting calibration on the date it was manufactured, and so state in detail the basis for your contention? Now, Your Honor, you recall quite a bit of the arguments made by Mr. Rasmussen, and I would say coupled with some of the arguments made by Mr. Robbins, go to calibration or conditioning of the ORP meter. And I found it somewhat comical that we were able to play the deposition testimony of a witness here who talked specifically about calibration and conditioning of the ORP meter after Hannah's proclaimed adamantly that there was no confusion about calibration or conditioning. But that has been a central issue when it comes to plaintiff's claims against Hannah and Milwaukee. So this interrogatory was presented to get to the heart of that issue, Your Honor. And then finally, interrogatory number 13 says, state when you discontinued selling the MA9025 conditioning and oxidation kit and all reasons that it was discontinued. Your Honor, if you recall last week Wednesday, I believe, we discussed that conditioning kit and how it was stopped in December of 2017. In fact, I read into the record to the court the email regarding how that conditioning kit was found to be toxic and how Hannah stopped selling it in the European market and eventually stopped selling it here in the United States. Now, so those are the issues in terms of the interrogatory, Your Honor. If you could go to Exhibit 3. These are the responses to requests for production, Your Honor. The requests at issue are request number 1, 2, 5, 11, and 16. Request number 1 asks that Milwaukee produce complete copies of all insurance, indemnity, joint defense, hold harmless, cooperative agreements, and it goes on, Your Honor, for several lines. If you go to line 18, it says, this includes, but is not limited to, any policies of insurance extending coverage. And again, it repeats the information from the interrogatory, Your Honor. In response, we have a reference to a single policy on page 3 of this document, Your Honor. Going to request number 2, says, please produce true, accurate, and complete copies of all statements, whether oral, written, recorded, transcribed, summarized, or otherwise memorialized, of any witness or other individual purporting to have knowledge of any issue in this matter, including statements by other defendants or other employees. This request, Your Honor, will go to the Rule 34 violations that we believe occurred here from June 17, 2022, when responses were due roughly 30 days from that point until where we are today. The response to request number 2 was, after a diligent search of its files, responding party does not have any documents responsive to this request. Now, I want the court to pay very particular attention to that response, because it comes 3 months after the request, but it also comes virtually a year, 11 months after Milwaukee's initial 16.1 disclosures. These documents, without the need for a Rule 34 request, should have been produced, John. Going to request number 5. Says, please produce true, accurate, and complete copies of any and all documents, including any labels, labeling, stickers, warranty booklets, instruction booklets, warnings, pamphlets, brochures, manual, or other documents provided for sale of any of the MW series of ORP meters between the years 2011 to the present. So we have a very healthy objection to this request, lines 9 through 18, and we get, in response, a few documents that does not appear to be an exhaustive list of everything that should have been produced. and we'll address that further in this motion. So those are the initial written discovery responses that prompted a letter to Milwaukee's counsel, what we would consider an EDCR 2.34 letter, asking for their documents. One other thing I want to point out, Your Honor, this is on page 13, is request number 14, which is seeking documents referencing any analysis to determine whether there's a potential safety risk involving calibration, maintenance of a platinum probe, or the need for probe oxidation. Now that should certainly refresh the court's recollection regarding the banter back and forth last week, where Mr. Rasmussen spent quite a bit of time discussing calibration and oxidation, hopefully bringing to the forefront how important these issues were and why plaintiff's written discovery was focused on getting to the bottom of any oxidation or calibration issues. In response to this interrogatory number 4, request number 14, if you go to page 14, lines 22 through 27, it says, after a diligent search of its files, the responding party does not believe it has documents responsive to this request in its possession. However, the responding party notes that Exhibit F to the responding party's first notice of compliance, filed and served in Wren versus Real Water, Affinity Lifestyles, and it provides a bait number. And then finally, Your Honor, request number 16 says, please produce, this is 16, by the way, please produce true, accurate, and complete copies of any emails sent by you to the manufacturer of the subject meter or received by you from the manufacturer of the subject meter from 2010 to the present. It says here in response, the responding parties conducted a search of approximately 10 years of emails to the extent that those emails have been preserved concerning the multiplicity of subjects, most of which concern the approximately 300 other projects the responding party purchases or has purchased from Hanna Instruments, and none of which are relevant to the claims and defenses asserted in the coordinated lawsuit. Now that's a pretty definitive statement, Your Honor. No equivocation there, I would suggest. So as a result of those responses, Your Honor, Exhibit 4 is plaintiff's counsel's request to prompt supplementation by Milwaukee's counsel. And let me say up front, and I said this to Mr. Robbins previously, this is not a criticism of Mr. Robbins or his firm in any way. I think counsel is bound by the documents provided by his client or clients, but it is clear that documents that should have been produced pursuant to NRCP 16.1, be it emails, letters, whatever other documents that would have been related to the request, should have been provided pursuant to 16.1 because they go to the heart of the claims and defenses in this case. And when it comes to insurance, again, 16.1 requires that insurance documentation to be provided because it also allows the plaintiff to evaluate the coverage for these claims and to determine how best to effectuate some type of resolution within, at times, policy limits if possible. And so that's been severely hampered, if not completely hampered, by not providing all of the insurance information. So Exhibit 4 is dated October 24, 2022. And this is correspondence again from plaintiff's counsel to Milwaukee, asking for supplementation of interrogatory number 4, 5, 7, 8, and 9, as well as 10 and 11. And you can see, Your Honor, plaintiff's counsel has explained why this information is first required, but secondly, why it's relevant. And again, this letter I thought was very detailed. Going to page 2, interrogatory number 9, it says here, plaintiffs asked for all insurance policies, and MI has responded by identifying a single Liberty policy with a $2 million products coverage. Interrogatory number 11, plaintiff's counsel indicates Plaintiffs contend that the subject meter was effectively designed, but did not limit it to the absence of self-adjusting calibration. Again, putting on the forefront the calibration issue. This question simply asks whether MI disputes that the meter could have been designed and made with self-calibration. When it comes to the request for production of documents, this gets to the parent company relative to insurance, Your Honor. Request number 1, which is actually interrogatory number 9. It says, again, plaintiffs are entitled to all insurance policies, including excess policies or named insured additions to parent SID or HANA instrument policies. To date, we have not received the SID policy, Your Honor. Request number 11 says, MI claims that it has no customer complaints whatsoever from 2011 to the present. Plaintiffs note that MI did not qualify this response to be limited to injury complaints as it did in the response to the corresponding interrogatory. That language, Your Honor, goes to MI seeming to place a caveat or condition on the complete response to that interrogatory and that request. And then finally on page 3 it says, given the position that MI has taken in the responses to requests for admissions 16, 17, and 18, where MI denies that any customer has ever complained that the meter was difficult to calibrate, and I want the court to really pay attention to that the meter was difficult to calibrate, that it was difficult to take negative ORP readings and with the meter, and or that it was difficult to clean the probes. It is essential that MI produce all communications that it has had with other customers. October 24, 2022. And then finally, request number 16. This request asks for all emails, and I highlight emails, Your Honor. Emails between MI and HANA Industries. MI admits in its responses not only that it has such emails, but that MI has reviewed them and that he searched for hit for MW500 with no results. Now, after sending that 2.34 letter, Your Honor, this issue was brought before Special Master Hale on December 14th, 2022. And I bring that to the court's attention because the court is familiar with the litany of cases dealing with sanctions with and without prior orders. This request, this motion, is not only supported by plaintiff's claims of violations of Rule 16, Rule 34, and Rule 34, but also based upon the order of the Special Master Floyd Hale. And what we've added to our exhibits, Your Honor, exhibit number 5, is the actual transcript from the Special Master hearing. And I would direct the court's attention to page 31 of exhibit 5. It's 31 of the transcript. We didn't provide the full transcript, Your Honor. There were several issues on the agenda. But Special Master Hale indicates at line 5 that the answers for MI would be due by the 29th of December. It says the insurance documents and the supplementation to prior discovery responses, December 29th, 2022 would have been the year, Your Honor. And Mr. Kemp, making sure he put a finer point on the insurance information, indicates at line 17, he says, and the reason it's important is because some of the clients become ill in 2017, 18, 19. Special Master Hale says, I thought we said 16 is the date people had to go back to. So that was the starting date for insurance, Your Honor, insurance information. But in terms of the other requests, all of the information had to be provided by the 29th. Plaintiffs' counsel, in an attempt to make sure there was no confusion, sent correspondence December 15, 2022, which was Exhibit 6, to MI's counsel, indicating Special Master Hale has ordered Milwaukee Instruments to produce their insurance policy, including excess policies from 2016 to 2021. He also ordered Milwaukee Instruments to provide previously discussed supplemental discovery responses as well. As per the Special Master, both the insurance documents and supplemental discovery responses are due December 29, 2022. There can be no confusion in terms of what MI's responsibilities were coming out of the Special Master hearing. But just to button it completely up, Your Honor, Exhibit 7 is the actual order. And if you go to the information and required documents on the second page, lines 22 through 25, it says plaintiff's counsel indicates that Hanna Instruments and Milwaukee Instruments have not produced required documents or their insurance information, including insurance policies dating back to 2016. This information must be provided by December 29, 2022. Following page, paragraph 4, Your Honor, lines 7 through 9. Hanna Instruments and Milwaukee Instruments must produce, they said produce, the required documents pursuant to NRCP 16.1 with their insurance information, including insurance policies dating back to 2016 by December 29, 2022. Your Honor, you have the transcript, you have the order, and you have a letter from plaintiff's counsel making sure there was no confusion with MI's obligation. Exhibit 8, Your Honor, is the follow-up letter. The day after the required disclosure date, December 30th, 2022, where plaintiff's counsel again indicates to MI that their documents and their supplemental discovery was required and that it had not been produced. In fact, the last paragraph says, as of today, December 30th, 2022, supplemental written discovery responses and additional insurance policy documents have not been provided. Please provide us the supplemental responses and the insurance policies by Tuesday, January 3rd, or we will seek relief through the special master. Your Honor, clearly all of the reasonable requests for an extensions have been granted by this time. The special master has been asked to get involved in this discovery dispute. We have an order. We have a letter after the order giving additional time to avoid further involvement by the special master. And then on January 3rd, we have Exhibit 9. This is a letter from MI counsel indicating that they need more time based upon issues with this client. And in fact, we'll read it into the record. It says, we are in receipt of the correspondence dated December 30th, 2022 regarding the outstanding issues in the above referenced matter. We are working diligently on being in a position to supplement Milwaukee Instruments discovery responses, as well as disclosing any additional relevant insurance policies per Special Master Hale's order of December 14th, 2022. However, in order to abide, we must communicate with certain individuals whom we have not been able to contact as of late. We have and are continuing to contact the individuals whom we believe will be able to assist in this regard. As soon as we obtain desired information in which to supplement the particular items Mr. Kemp dutifully identified in his original letter dated October 24, 2022, regarding the alleged deficiencies in our responses and additional disclosures, and if any, we will immediately comply with the order to the best of our ability. So the obligation is recognized and acknowledged in this letter, Your Honor. The time has come and gone to produce. That's also acknowledged. There appears to be a lack of ability on MI's counsel's part based upon the client. At this point, it does not appear that MI's counsel was fully aware of the situation involving Mr. Brown. And that's going to be, of course, is addressed in MI's opposition. But based upon the answers in interrogatories, Your Honor, you've seen this in our motion to designate as a person most knowledgeable, Mr. Brown, that in addition to Mr. Brown, the owner of the company was also identified in interrogatories and apparently from the deposition testimony available to assist in the discovery of this case. That we know. So, Your Honor, January 11, 2023, plaintiff supplements its motion to strike. And this supplementation deals really with trying to get the deposition of Jason Brown completed. And it says here, plaintiffs have sought to depose Mr. Brown since October 22, but have been repetitively met with delays, excuses, and refusals to appear. Now, Mr. Robbins' opposition has made clear that at some time in October 4th, I believe, 2022, Mr. Brown was admitted to the hospital with COVID, I believe, Your Honor. And he remained in the hospital for an extended period of time. Ms. MI believes that Mr. Brown's inability to participate excuses them from actually fulfilling its obligations under Rule 16.1, Rule 34, Rule 32, and the Special Master Order. It appears that the argument is that because Mr. Brown was sick in October, that for some reason Milwaukee could not have complied back in October 15, 2021, virtually a year before, when it actually produced its initial disclosures, and every day and every month, every week between October 15, 2021 and October 4, 2022, when Mr. Brown was admitted to the hospital. They couldn't have complied from June 17, 2022 to September 26, 2022, when they were preparing responses to the initial interrogatories and requests for production of documents. That appears to be the bulk of the arguments made in the opposition, Your Honor. What I would point the court to, and this is kind of a prelude of where we're going eventually, Your Honor, in this motion. We have cases in Nevada, the Supreme Court has decided, where not providing a witness for deposition has led to the striking of an answer. Not providing witness statements or identifying witnesses have led to having an answer struck. Not properly complying with Rule 16.1 has occasioned an answer being struck. We have in this case a delay in a deposition, a violation of 16.1 to the present when it comes to the insurance, violation of 16.1 when it comes to discovery, the production of disclosures without the need for written discovery, and thereafter violations of the rules in terms of interrogatories and request for production documents in addition to NRCP 16.1 violations. Exhibit 1 to the supplementation, Your Honor, is the agenda for the Special Master Order. And we bring this to the court's attention just so the court can understand that the Special Master hearing of November 3rd, 2022 asks for the status of the deposition of Milwaukee. This is item number 9, by the way, Your Honor. The status of Milwaukee employee Jason Brown's, the status of deposition of Milwaukee employee Jason Brown. A copy of plaintiff's request letter is attached as Exhibit 1C. And so, Your Honor, if Mr. Brown could not be produced because of his illness, then certainly under Rule 30, someone else could have been prepared for that deposition. Now, eventually, that deposition did take place. It took place February 3rd, 2023, after Mr. Brown was released and had returned to work. Now, Mr. Robbins will argue that Mr. Brown came to this deposition too soon after being released from the hospital, that he was not completely well, and as a result that affected his ability to assist in discovery and to provide complete testimony. Again, Your Honor, we didn't designate who the 30B6 witness would be. That was done by MI. Someone else could have easily been designated. Perhaps the owner could have been designated. Someone else could have been brought up to speed. But in a case of this size and magnitude, it should not have to rest on one person's availability. Now, Mr. Brown, Your Honor, has been determined to be a speaking managing agent for Milwaukee. And during his deposition, he gave testimony that brought to light and revealed to the plaintiffs that Rule 16.1 had not been complied with, and in fact, it appeared that documents had been withheld intentionally. And again, I say that without casting any aspersions as to Mr. Robbins. I don't believe he would have known what's in his client's electronic files or hard copy files. I'm not assigning blame to him. But it appeared to have been MI's position that they had produced all the documents, because on January 13, 2023, Milwaukee produced its first supplemental list of witnesses and documents pursuant to 16.1. And that supplementation contained what they believed to be all of the information available to Milwaukee that was responsive to the concerns expressed in plaintiff's October 24th letter, other than the additional insurance policies. So, Your Honor, I want you to take a look at defendant's opposition. And this is page 8 that I'm reading from. Because quite often, Your Honor, I ask the court not to take my word on the chronology of events. I try to show the court the actual documents that I'm utilizing to support the plaintiff's position, so that the court, in a completely unbiased fashion, can determine the factual events leading up to this motion. But on lines 1 through 8, Your Honor, defendants, as of the date of the filing of this document, February 16, 2023, believed that it had produced its responses as of January 13, 2023. And you'll come to find out later on in this presentation, Your Honor, that that was simply not the case. It says these supplemental productions, this is line 3, and responses contained all of the information available to Milwaukee that was responsive to the concerns expressed in plaintiff's October 24th letter, other than the insurance policies. On January 24th, 2023, Milwaukee served defendant Milwaukee Instruments' second supplemental list of witnesses and documents pursuant to NRCP 16.1, attached to the opposition as Exhibit P. This production contained copies of Milwaukee's policies from 2016 through June 2022. So now these are the underlying policies. The SID policy, again, Your Honor, has still not been produced. But this is an indication from Milwaukee itself that it was supposed to address the October 24th letter, which preceded the special master hearing in December of 2022. So certainly there's acknowledgement that the SID insurance policies should have been produced. And here there is clear that those policies have not been produced as of the date of the supplementation, and I would say as of today's date, Your Honor. March 15, 2023, Your Honor, plaintiff files its reply in support of its motion to strike Milwaukee's answer. And if you go to page 3 of this document, Your Honor, plaintiffs explain at the top of page 3 why this supplementation is being provided. Number 1, it says, to date, Milwaukee Instruments has not complied with the December 15, 2022 special master order. Number 2, insurance policies for the other related and parent entities have not been produced. The Facebook consumer complaints have not been produced. The emails between Hannah Instruments and Milwaukee Instruments and emails which were exposed at Mr. Brown's deposition have still not been produced. Number 5, it says Milwaukee Instruments had every opportunity to gather information but did not do so. And then number 6 is sanctions no matter warranted due to the continued dilatory efforts of Milwaukee Instruments. Your Honor, if you would go to page 5. Page 4 and the beginning of page 5 documents, again, the history leading up to the special master order, and then up to Mr. Jason Brown's deposition. Starting at line 17, it says, Mr. Brown screen shared his computer screen to display an unproduced email directly related to a calibration issue central to the present matter. As to this email, it was asked, question, So you think there's something missing here. And this is Mr. Brown informing plaintiff's counsel during the deposition of something that he recognizes being missed in the production by Milwaukee Instruments. The answer is, it's not in order, yes, because there should be a continuation of this email. And so Mr. Brown is actually putting on the screen, and this is being done, Your Honor, while this is happening. We didn't have this information before the deposition in terms of disclosure. It wasn't given to us minutes before the deposition started. This was happening in real time. Question. On Exhibit 2 in your book here, the bottom page 192, for some reason, the text of that February 22nd email is not included. Then he says, like I said, Carl is the one who scanned this stuff. Now, Carl is Carlos Savaggio, the president of Milwaukee Instruments. The person identified in the answers to interrogatories, someone who appears to be scanning documents, who could have been able or should have been able to assisted in complying with 16.1, complying with interrogatories, complying with the request for production, and certainly complying with the special master order. So utilizing Mr. Brown as a way of escaping the obligation, I do not believe to be a very persuasive position to take. We understand and sympathize with his having gone through COVID. A lot of Americans did, but we were able to continue on through the use of others involved in this process. And I would have suspected that MI could have used Mr. Savaggio to have done the same. So if we go to page 8, Your Honor, this part of our brief actually indicates, it says, in addition to Jason Brown, this is line 15, Your Honor, for the court's benefit, Carl Savaggio was identified in Milwaukee Instruments responses to plaintiff's interrogatories as the president of Milwaukee Instruments, presently employed. And it says here, Carl Savaggio was seemingly involved in the daily operations of Milwaukee Instruments, as he was one of the persons who regularly answered customer inquiries on a regular basis, especially when Mr. Brown was out of the office. In fact, as provided by Jason Brown in his deposition, Carl Savaggio was the person who put together the limited email correspondence referenced above that was produced to plaintiffs prior to Mr. Brown's deposition. Now, when you consider that, Your Honor, when you consider Carl Savaggio being involved in email communication, Mr. Jason Brown, on the fly, being able to bring it up in real time during the deposition, it brings into question, was the remaining part of this issue, calibration or conditioning, which is so central to the defense of Milwaukee and Hannah, how could that have been removed or deleted or withheld? It makes no sense. It makes no rational sense, Your Honor. If you go to page 7, and this is not very easy to read, Your Honor, but there are two organizational charts here. And you see it says Organizational Chart SID International. I don't know if you can see it, Your Honor.
Yeah, I can see it.
And then we have the circle here for Milwaukee Instruments. So when we were asking back in October for these insurance policies, we expected to get the insurance policies for these parent companies, which to date, I don't think Mr. Robbins will argue, we've not been provided those insurance policies. So at the conclusion of this brief, Your Honor, we asked that pursuant to the Bahena versus Goodyear Tire and Rubber Company case, 126 Nevada 243, decision in 2010, that Milwaukee Instruments' dilatory efforts rose to the level to permit striking of their answer. Since then, Your Honor, there's been more that we provided in the way of additional or supplementary briefing. But, Your Honor, I wanted to show you as Exhibit 1 the type of chat information that we were expecting to receive, which also supported why we suspect that there's more documents out there that we have yet to receive. And if you go to the second page of Exhibit 1, base stamp MILW001848, says at the top, actually the bottom chat communication under 10:13 a.m. says, how can I get a negative ORP reading of minus or negative 400 and above. These are the types of instructions or requests for information we believe are still missing from their disclosures. We've also attached the deposition of Jason Brown so that the court can see for itself. This is Exhibit 2, Your Honor. The exchange between plaintiff's counsel and Mr. Brown, and how it was discovered that this email, the full email, had not been provided to us. Your Honor, I don't want to read the whole, all 4 pages of it, but if you go to page 60, it speaks of Mr. Savaggio's involvement, lines 7 through 22. And he talks about Mr. Savaggio being involved in these communications, these chat communications. And if you go to page 61, it says here that Mr. Savaggio, looking at lines 7 through 11, was more involved with answering these while I was out sick. Another indication that Mr. Savaggio could have been involved from the 16.1 disclosures through the answers to written discovery. And then finally, Your Honor, if you go to page 134, this is where we find out that a part of the email dated February 22nd, 2019 had been withheld. And it says here, line 7, it's not in order, yes, because there should be a continuation of this email. Your Honor, what we saw at the time, original disclosure, was just the heading and the subject line with no response or no further text. And if you get down to line 18 on the same page, bless you, it says, so you think Mr. Savaggio, in your absence, provided these emails, correct? Yes. He scanned everything I have. So now, given that Mr. Brown provided during his deposition, it would only lead to the conclusion that Mr. Savaggio, the president, withheld that information or failed to disclose it if we're going to give him the benefit of the doubt. What we do know is that plaintiffs did not have it prior to the deposition of Mr. Jason Brown. So Mr. Kemp, I believe, in an attempt to ensure that he had the information from this email, read it into the record, had Mr. Brown read it into the record. And it says here, starting at line 25, page 134, what I'm saying is he may have gotten me the thumbs up. Let's scroll back down. So he reads it. Good afternoon, Mike. Here's a link from our website. Hope this information is helpful. This is simply the conditioning negative ORP link that was on the old site. So then the question is stop. So that reference there is Exhibit 10, right? Yes, sir. As you can see by the date here, where my cursor is, this is March 19th. So obviously this is before the new site was up. This is the old website. Question. So the email to Mr. Brown, that's Exhibit 2, page 192. The reference to the information there that you were forwarding to him, that is Exhibit 10, correct? Yes. Go ahead, and he answers. If I scroll down a little further, you'll see he's asking. And this is the information that was left out. Hello, please send us instructions on how to properly calibrate our older ORP probes / meters. Do the new meters need to be calibrated? Your Honor, that's the heart of this case as it pertains to Hannah and Milwaukee. And that language was excluded from the disclosures that plaintiffs received from May 12, 2021, when the complaint was filed, October 15, 2021, when Milwaukee did its initial disclosures, over a year and a half before. And this crucial email, the top was provided, but not this information, was withheld. How do you take an email and white out or remove this language? Now, I applaud MI and his opposition for trying to find a way that could happen. But it's a nonsensical position to take. because this information is so important to the issue. There's no reason why any query would have not included it. But when you have the top of the email, to and who it's from, with the subject matter indicating ORP, how do you not include this information? Then if you go to page 138, it says, which you know, they're factory calibrated. So you're conditioning the probe, you're not calibrating the unit. That is a continuation of Mr. Brown's response to the question, Your Honor. And then again, Mr. Kemp goes through one more time, making sure that everyone at that deposition, mainly Mr. Brown, understands that at the bottom of page 192, Exhibit 2, did not include that information, Your Honor. And he has them read it into the record, line 17 through 22, Your Honor. So that's why that supplementation is so important. That deposition just took place. We believe we have the universe of documents to depose the 30B6 witness, and during that deposition we find this out. Now, Your Honor, while we're talking about this, I want to give the court just a basic chronology of the dates and times of certain events. Following the initial disclosures by MI, the first set of written discovery, the meet and confer letters, the special master order, the motion to strike, the Milwaukee second supplement, Jason Brown's deposition, third supplement, the expert disclosures, and the fourth supplement. I'll give this to Mr. Robbins so you just have it. I don't know if anyone else, I'll give one to Mr. Rasmussen, Your Honor. May I approach?
Yes.
Is this in the brief?
No, this is demonstrative. It provides the dates. If you find a date that's incorrect, let me know. But I believe these are dates that are discovery dates and deadlines, as well as the exhibits, gives the dates of the exhibits that are already here in the record. And I am using this, and let me give Mr. Robbins a chance to take a look at it. I don't know, Scott, if you need more
You
time.
can go. I'm going to just state an objection for the record because I'm
Go
trying to see if it's correct on the fly. I mean, generally, it's dates
Yeah.
look appear to
If
be
they want
correct.
to take a couple minutes, I'm fine. I want to make sure that there's no.
No, I'm still going to
concern
object
about
because
dates.
I'm not going to do this on the fly. So I'm
No
going to
worries.
object.
Well, I think all it is, it's my understanding, this is just a timeline.
That is your honor. Yeah, I'm just saying I don't know if these are correct dates or not on the fly. So they generally look like the same dates to me that I would argue to you, but I can't say for certain right here on the fly.
Mr. Parker, I'm not involved in any of these things, right?
No, I don't believe so, but I gave it to you just as a courtesy.
Thank you. I just want to make sure. I'm not involved in any of that's good.
No, this is not your motion.
I mean, for the record, I don't mind saying it, I look at this as no different than a PowerPoint. And what I mean by that is it just has the dates in chronological order from October 15th through May 19th of 2023.
That's correct. So, Your Honor, this timeline puts in perspective how much was being done between the October 15, 2021 and the deposition of Jason Brown, February 3rd, 2023. And it also gives the court an understanding of the subsequent disclosures by Milwaukee and the expert disclosures. So, Your Honor, we find out during a deposition that the main issue in terms of warnings against Milwaukee and Hannah has been identified in a email that was not produced during discovery or produced in response to written discovery, and actually there's the briefing that preceded it that said that everything had been produced. So, on August 2nd, Your Honor, 2023, this is a supplemental motion to strike. Again, a continuation of this briefing. And it includes what we found out in the deposition. And it describes and shows the actual email, how we received it, up until the point we took the deposition of Mr. Jason Brown. If you were to look at page 3 of this supplemental brief filed August 2nd, 2023. And here, Your Honor, you can see at the bottom email, and this is a paper, you can see it's imposed here on this pleading, Your Honor, this pleading paper. But if you look at lines 24 and 25, you see the subject line, and this takes a keen eye. It's from Mike Bush of Real Water, sent February 22nd, 2019, the same date that's referenced in Mr. Brown's deposition. And you can see the bait stamp here, MILW000192, and it's to Milwaukee Instruments Sales Department. Subject, calibration of ORP probes / meter. That's the subject line. And what we got, Your Honor, was blank. There was nothing, no language under that subject line when we received this document from Milwaukee Instruments, Your Honor.
I apologize, Mr. Parker. What document is this coming from?
Oh, look at our supplemental brief of August 2nd, and it's got the bait stamp number on the bottom of it.
Your supplemental.
Yes. If you want, you can take a look at mine. It's got some highlights.
I'm going to point this out here. Page 3 of your supplemental brief.
That's correct.
Okay, thank you.
You're welcome. And you can see what's missing, Your Honor. And then after the deposition, we finally get the information that I've read into the record, and you see that reflected on page 4. And that's the information that should have been in the original email. Now that I've had a chance to look at everything, because I was preparing to argue this motion initially over a month ago, Your Honor, I think I brought fairly objective eyes to it when I reviewed it and got prepared for it. And there's no other explanation I can come to if Mr. Jason Brown is being honest. If he's being honest that Mr. Salvaggio prepared and scanned the documents, the communications, then he, as the president, would be responsible for this information not being there. Because I'm not attributing it or assigning it to Mr. Robbins. I'm sure he didn't do it. Mr. Jason Brown brought it forward to us during his deposition. So that only leaves one person culpable, in my opinion, given where we are. And who better to take the responsibility for this company than the president? Because certainly that document should have been produced on October 15, 2022. I'm sorry, Your Honor, October 15, 2021. So, Your Honor, if you go to page 5 of the supplement of our brief, it indicates that the complaint alleges, this is line 12 through 13, that due to the failure to warn, Real Water did not properly understand how to calibrate the probe of the ORP. So there's no way Milwaukee could argue that they did not know that this was a part of the case. It's impossible, unreasonable, it would be disingenuous to argue such. In fact, we point out again the written discovery request that I've already informed the court of here on lines 18 through 24, Your Honor. And then on pages 6 and 7, we go through the testimony again of Mr. Brown, but we also talk about Mr. Bush, and that he explicitly asked for calibration instructions. So, and I hate to pick on Mr. Rasmussen right now, but Mr. Rasmussen spent quite a bit of time trying to explain to the court that the ORP meter has nothing to do with hydrazine. We didn't say that the ORP meter created hydrazine. We didn't say that the ORP meter would measure hydrazine. So we didn't say it didn't create it, didn't measure it. But what we did say is, if your user does not understand how to use it when it comes to calibration or conditioning, whatever word you want to use, resulting in additional concentrate being used, and you fail to warn them on how to use it properly, then that's something that you can be responsible for. And that's what we said in our complaint. And having that issue at the center of plaintiff's claims against Milwaukee or Hannah, those documents and that email was obligated to be produced October 15, 2021, if not sooner. And so, Mr.
What was the
Bush,
date of that email again? That email was dated, what,
February 22nd, 2019.
Yeah, I just want to make sure I
before.
got that date, yeah.
Yes, sir. Yes, sir. And again, that's a very important date because keep in mind, that's before the super outbreak in 2020, but it's also before Mr. Haley's illness and admission to the hospital. And what's also important is another importance of that document and the timing of it is that it's only a few months, less than a year after Mr. Belsky has been admitted to the hospital. And if you refer back to the MMWR report, you had the spikes 17, 18, 19, and then the gigantic spike in 2020. So when you consider that the ORP conditioning kit was removed because of toxic issues in 2017, and then you have the injuries in 18, 19, culminating in the very large group of injuries in 2020, you see the relationship, the direct relationship between Hannah, Milwaukee, and the real water outbreak. And there's no escaping it. But what we have in front of us today is a clear indication that perhaps Mr. Savaggio recognized that issue. Perhaps Mr. Savaggio, in an attempt to prevent this information from coming to light, withheld it from Mr. Robbins' firm, removed it from this document, but made the fatal mistake of not removing the subject line. Now, Mr. Bush testified that had he known how to properly condition it, he would have followed the warnings. And this is on page 7, Your Honor. And this is important to read, and I believe, Your Honor. It says here, this is again questioning regarding the conditioning. And it says here at line 7, this was my mistake. So would you agree with me that when Real Water asked for information on how to calibrate, that you did not give them the correct information? This is Mr. Brown. I did not give them the correct information because I thought they were the one that had the kit. That is right. So Mr. Brown was honest enough to admit that he gave wrong information in terms of calibrating or conditioning the meter. And Mr. Bush says, lines 14 through 16, but if it would have been done for sure, question, if they had told you to put in the vinegar for 4 to 5 days, would you have done that, correct? Yes, I would have. Indicating that had he been properly instructed on how to condition or calibrate this meter, he would have followed those instructions. And then again, the preceding testimony from Mr. Brown is he gave him the wrong instructions. Your Honor, on March 1st, 2023, Milwaukee claimed that they had produced all of the documents. And this is exhibit, this is reference of the whole documents provided. This is Milwaukee's third supplement to its list of witnesses and documents pursuant to 16.1. Robert's reference, but I don't know if the whole document's there. Your Honor, may I approach?
Yes.
Thank you. Your Honor, I'm not going to ask you to read. I'm not going to read too much of this. This is dated June 8th, 2023, the day before close of discovery. I believe it was June 9th. And if you go to page 17, Milwaukee says this is item number 11. So page 17, line 11. And then the exhibit letter, I should say, is W, as in whiskey. It indicates that this bait range constitutes the complete email chain between Milwaukee Instruments and M. Bush of Real Water, final date March 19, 2019. So we believe as of that date, we have everything. We got all the documents, and lo and behold, 2 months later, a little more than 2 months later, May 19th, Milwaukee filed its supplemental disclosures, filed a fourth supplemental disclosure, and indicating that they found additional documents. And these additional documents is an email where they said they gave the right directions to Real Water on how to calibrate their meter. Sorry, which one is it? Your Honor, may I put you one more time?
Yes.
And so this is dated May 19th, Your Honor. And what we wanted to make the court aware of is that May 19th, after all of the expert disclosures are done, and if you look at this timeline I gave the court previously, the expert disclosures were initial expert disclosures of March 24, 2023, and the rebuttals May 25, 2023. They choose, after all of the expert disclosures are done, to produce additional documents after telling us 2 months earlier that all of the documents had been produced. So the supplementation was for the purpose of making sure that these late disclosed documents would not be admitted because they were claimed to exonerate in part or help in the defense of Milwaukee. But additionally, Your Honor, we wanted to show what I consider to be Milwaukee, not its counsel, but Milwaukee's gamesmanship related to our discovery rules and orders in this case. And Your Honor, here is a list of all the depositions taken in this case. And it has the expert reports here. And I wanted to show just how much has been done in this case up to this point. Microphone, Your Honor.
Yes.
Give the court a clear understanding of how much work has been done in this case prior to this final realization by Milwaukee that there's additional documents. The plaintiffs had produced 9 expert reports, initial and rebuttals. UNF, 4 initial experts and rebuttal reports. Real Water, 7 initial reports. Hannah, 4 initial reports and 3 rebuttal reports. And Milwaukee, 4 initial and rebuttal reports. All prior to this May 19th fourth disclosure. Giving the court an understanding of just how much time, effort, resources have been dedicated to completing discovery in an orderly fashion in accordance with the dates and deadlines ordered by the special master. To find out that there are documents that still have been withheld throughout this process. Your Honor, I would have the court take a look at page 11 of our supplemental brief of August 2nd. This is there's a list of 8 discovery violations we believe that have been committed but I believe it's actually 9 because we forgot to add in this list a number 9, which would be the failure to produce the SID insurance policies, Your Honor. I'm not going to read all 8 of these into the record, but generally, Milwaukee failed to produce its initial, as a part of its initial disclosures, documents that should have been produced under 16.1, as well as the insurance information on October 15, 2021. Failed to provide an explanation as to why those documents were withheld, and in terms of insurance policies still being withheld. Despite claiming that they produced all their emails as of March 1st, 2023, we received emails thereafter, 2.5 months later, failing to provide an explanation as to why those documents were provided 2 months after saying they had produced everything. Failing to explain or provide all communications between itself and Mr. Bush of Real Water. It's failing to provide all documentation between it and Hannah. Failing to provide all emails related to customer complaints, all chat communications. Your Honor, we have no reason to believe at this point that all information has been provided by Milwaukee. Your Honor, when you consider this backdrop, this factual backdrop against the case law of the state of Nevada, there's no way to explain or excuse Milwaukee Instruments conduct. The last thing I want to provide to the court, Your Honor, is a copy of the actual emails, so the court can see the before and after. These are referenced and in part shown on the briefing, but I wanted the court to actually have a copy of it. I apologize. Your Honor, may I approach?
Yes.
I'm giving the court 2 documents, Your Honor. I'm giving the court the February 22nd, 2019 document, which is the first document, base stamp MILW 003648 through 3653. And the second document is MILW 004924 through 4930. If you look at the bottom of 3648, you see this exchange begins on February 22nd, 2019. I apologize, 11:53 a.m. And Mike Bush originally to Milwaukee, and then it's Milwaukee to Mike Bush, where Mr. Jason Brown is referring Mr. Bush to the website, the old website. The second page is the critical page, Your Honor. This is what was missing from the production until the day of Mr. Jason Brown's deposition of February 3rd, 2023, 4 years later. All we had originally was subject calibration of ORP probe / meter. We had this language was omitted, removed, deleted. Something was done to it. It says, hello, please send us instructions on how to properly calibrate our older ORP probes / meters. Do the new meters need to be calibrated? And this is, Your Honor, you can see this is ahead of Real Water ordering more meters. So that's what this, I wanted the court to have this email in its possession as opposed to just a cutout of it in the briefing. And then the second email, Your Honor, shows the what we received, and you can see there's nothing there. If you go to the second page, it says calibration of ORP probe / meter. This is MILW 4925. If you compare it to what I just read into the record, Your Honor, you see that language is gone. I don't think there's any way to explain it. I don't think there's any way to excuse it. And certainly, given the timeline and everything that we've done on this case to get it where it is, Your Honor, there's no way of ignoring the prejudice plaintiff's position. Given the Bahena case, the Valley case, Your Honor, this case, the severe sanctions are required, and we've given the court our position on the factors on the Young Ribeiro case, and I think they all support a severe sanction. Now, plaintiffs have considered the timing of this motion, and in particular, the timing to have an evidentiary hearing. We understand that there's very little to no time for that. And if the court's unwilling to do an evidentiary hearing, given the proximity to trial, we believe that under the Clark County School District case, as well as the Bahena case, that a evidentiary hearing is not necessary if you're simply striking the answer for purposes of establishing liability. And I look forward to addressing whatever Mr. Robbins has to say in opposition. Again, this is not a criticism of Mr. Robbins' handling of this file. I believe Mr. Robbins was only reacting to what his client's misconduct.
Okay, thank you, sir. I don't know, Mr. Robbins, it's up to you, sir. Want to take 5 minutes?
It's really up to the staff. I probably should give the staff a break here. I'll be much briefer than that, but I think it's probably due for a break.
Stay tuned.
All right. Now it's still briefer.